Good morning. This is Jeff Sloan with Mark Gregersen. Welcome to our webinar on the Janus case, which was not entirely a surprising case, but it raises a lot of issues for us to talk about. I want to start with a little bit of housekeeping, and I've got 7 points or so to go over with you quickly. First of all, this matter is being audio taped. The audio tape will be available to anyone who asks. Send an email to info@sloansakai.com or use the chat feature. Second of all, for lawyers, we are giving MCLE credit for this seminar. Whoever's in the room with you lawyers who is keeping track of your time, please send us the list of attorneys to info@sloansakai.com and we will send out certificates. Third, bear in mind that participants are muted. We are not hearing what you have to say, but hopefully you're hearing what we have to say. Fourth of all, use the chat feature at the bottom of the screen for questions. We invite questions, and let me tell you a little bit more about that. As you will see in a minute, there are 5 modules in this webinar. And if you can look at the modules once you see the next page, the agenda page, understand that we will be grouping your chat questions in those specific areas. And assuming time, we will be covering those at the end of each area. If we haven't covered them all, and if there's time at the end, we'll be covering them then. And frankly, we're not sure, given that we don't know how many questions there are going to be, we're not sure that this is all going to pack into an hour. And if you tell us, particularly you lawyers who may want 1.5 hours credit, if you tell us soon that you want to hold over for more questions in the event that we don't finish in 1 hour, let us know that by chat and let us know soon so that we can plan accordingly. Next point I want to make to you is that this is not a confidential webinar. We are not able to ascertain exactly who is on the webinar to the extent that any of our union or union counsel friends are listening in. Welcome. Obviously, this isn't an attorney-client privilege seminar. This is just for information, and as we will indicate in our caveat in a minute, you need to consult counsel or qualified representative in the event that you actually want to get legal advice upon which you can rely. I've compacted one of the points that I've made. The final point is that there is a toolbox that we've sent out to clients and other friends relative to how we think, as a general matter, you should be or can be addressing Janus compliance. And to the extent that you haven't gotten it and you want it, send up your request by chat or to the Sloan Sakai email address, and we'll get that over to you as soon as we possibly can. This seminar is going to work fine even if you do not have the toolbox. So welcome. You know me, at least a lot of you do, I think. I think a lot of you also know Mark Gregersen. Mark is the former chair of PERB, who recently rejoined the firm as a senior consultant with our consulting arm. Our consulting arm has been newly titled the Management Strategies Group, and you'll be hearing more information about that very, very soon by him. So Mark, my friend, welcome. Mark and I have worked together for many years before he became a neutral. And you'll see in the e-alert notice some of his background, but Mark has a very, very strong background as an HR manager, serving as Director of Human Resources in a variety of jurisdictions, as well as doing a lot of negotiations work out in those variety of jurisdictions. The caveat I've already kind of made a reference to. Our legal counsel has advised us that we advise you that nothing herein constitutes legal advice, and get formal legal advice from your attorneys or from other qualified representatives. Here's our agenda, and you'll see that there are actually 6 pieces to the agenda, and we'll be grouping your questions as they come in into those 6 pieces. 1, agency shop defined, because actually there are a couple of issues about agency shop that we want to talk about. We're going to spend just a little bit of time talking about Janus, not more time. You can read the opinion, and the key question not is what does it say, because we know what it says in essence, but the real question is compliance, and what does the future hold for us given the Janus holding. We're going to talk some about union-friendly legislation that the legislature already put in place in anticipation of Janus. And we're going to go to something that's covered to a fair degree in the toolbox, which is immediate compliance requirements for public employers and also for unions in light of Janus. Then some pointers about how to be prepared for the next wave of Janus, and talking then about anticipated union actions. And we're actually very curious about what you have seen in terms of union actions that are already in play. What have unions told you? And if you got time to pop that into a chat, we would really be happy to hear about that too. With that, we are going to move to, if my computer is cooperative, to the issue of agency shop defined. And Gil, while you're working on that, Mark is going to talk a little bit about that.
So thank you, Jeff. Yeah, let's just talk so we have a common definition of agency shop. Agency shop is really known by a number of different names. Agency shop, it's called organizational security, and it's also known as a fair share fee. And the common elements between all of those titles is it involves a compulsory payment to the exclusive representative by non-member employees of some amount of dues and initiation fees and assessments. Payments are subject to rebate for activities not germane to collective bargaining by a rather complex procedure. And agency fee payers also include religious objectors who are required to pay a charitable contribution instead of to pay the exclusive representative. Another form, and this is different, maintenance of membership, and that's a quite a common provision in some collective bargaining agreements. If you haven't heard of maintenance of membership, my guess is that at the bargaining table you will be starting to hear about maintenance of membership. It's a different concept. It covers employees who voluntarily agree to be members of the union, and it requires that those members continue their membership during the life of a collective bargaining agreement. And as I had mentioned before, maintenance of membership is relatively common, though it's not even referenced or defined in some of California's collective bargaining laws, including MMBA. The important thing to realize about those differences, those two different things, is the legality of the maintenance of membership was not a question in Janus. It is a separate matter.
And I doubt that maintenance of membership is going to end up being unconstitutional too, because when somebody becomes a union member, then they have chosen to be a member, and they have chosen, in essence, to abide by the union's constitution and bylaws, and so on and so forth. So a little bit about Janus versus AFSCME and its reversal of the Abood case, long-standing precedent that the Supreme Court actually said it was wrongly decided. So technically, it's not only unconstitutional now, it's been unconstitutional since the beginning, a rather interesting way that the Supreme Court analyzed it. So very, very quickly, I just want to review with you the key cases that occurred during Abood's lifetime. You know, we started with Abood, which basically said that agency shop is constitutional, relied a lot on the issue of free riders, and said free riders really don't have a right to refrain from paying monies to a union if management and the union negotiate agency shop, which requires compulsory payment, although not membership. That was followed by a couple of cases that really developed an issue in Abood relating to what happens when the union is spending money for purposes unrelated to collective bargaining. And both of these cases set up a structure and a process whereby objecting non-members could have an airing, typically before an arbitrator in California, statewide arbitration, where in essence, the arbitrator decided what proportion of the union spending was for purposes unrelated to collective bargaining. That was criticized in the majority opinion in Janus. Next was a wave of cases that resulted in Janus's determination of unconstitutionality. Starting in 2012, there was the Knox case that questioned Abood as precedent. There was then Harris versus Quinn, which really, really questioned it as precedent. And then, as I'm sure all of you know, the Fredericks case in 2016, coming out of California, went up to the Supreme Court. The Ninth Circuit, our Ninth Circuit, decided that in light of Abood, agency shop was of course constitutional. The Supreme Court granted review, and then Justice Scalia died. It took 4 votes to grant review. Once you get 4, it's pretty clear that there's going to be 5 or more somewhere. The court deadlocked after Justice Scalia died, resulting in affirmance of Abood on a non-precedential basis. That led us, next slide, please, Gil. That led us then to the Janus case. And the Janus case essentially held, as we all know by now, that agency shop violates the First Amendment rights of non-members. Janus also held, in essence, this is a quote, neither an agency fee nor any other payment to the union may be deducted from a non-member's wages, nor may any other attempt be made to collect such a payment unless the employee affirmatively consents to pay. And the court emphasized the waiver has to be freely given, shown by clear and convincing evidence, and unless employees clearly and affirmatively consent, then the union can't collect. And for those of you who haven't read Justice Kagan's dissent, you should read it. It makes for good reading, and it was a truly impassioned dissent. Immediate and anticipated impacts are, number 1, loss of agency fee, of course. That's going to affect each union differently. Unions with a lot of membership, which is typically police and fire unions, and maybe some others, are going to see only a minimal impact from Janus. But those who are representing service, clerical, lower wage employees are going to likely see a significant impact. Some unions have agency fee levels at 50% or more. And if a union can keep half of those fee payers, that still represents a 25% reduction in income. And we'll be talking about the fact that unions are seeing a need not only to reduce their expenditures significantly, but also to focus on organizing and increasing their memberships. And I'm sure that a lot of you have seen examples of that in your jurisdictions by increased union concerted activity.
So the next thing that we want to briefly talk about is union-friendly legislation in anticipation of Janus. There has been a lot in the state of California, and we want to go through and touch on some of the major pieces of legislation. So the first one we want to talk about is AB 119. It was signed by the governor, 6/27/18. And it does a number of things. It requires employers to allow union participation in new employee orientation sessions, including providing 10 days advance notice to any new employee orientation. It requires the employer to provide the union the name, the job title, the department, the work location, the home, the personal cell phone number, personal email address, and the home address of new employees within 30 days of hire or by the first pay period following the month of hire. Further, not only does it establish that requirement, but the employer needs to provide the union that information every 120 days for all employees. The union can request bargaining over the structure, time, and the manner of access to the new employee orientation. And if the parties are unable to reach agreement over access to orientation sessions, any dispute then would be resolved through binding interest arbitration. Then there's AB 2970. It's really not law yet. We just mention it because it is circulating out there, and it's still in committee, but to a very great extent, the language that was included in AB 2970 is included in SB 866, which we'll talk about in more detail in a few minutes. So the next element, piece of legislation that we want to mention is AB 119, confidentiality of employee information. These are key issues, and would ask that Jeff would kind of talk about some of these key issues raised by AB 119.
Yeah, so the legislature went all out on this one. Employee information, personal email addresses, personal cell phone numbers, we got to turn those over. Well, what about the issue of whether your orientation sessions were non-traditional or individualized rather than being group orientation sessions? Large jurisdictions sometimes have group. Small ones typically is one-by-one. So let's say you're a larger organization, you've got something beyond individual, you've got group. Union says, no, we want to be able to access individuals. Do you have to do that? My answer in general, you know what? This is subject to collective bargaining under this statute. What about the content of the union presentation? Do you have a right to look at and to give feedback on a union presentation? Now, that's not covered in legislation. A union is certainly going to say it's none of your business as to what we say to folks. I think we all have a sense of what they would say, which is you need a union. But you might consider something like, before, as part of your negotiations with the union on this, if they're pressing you on any particular point, ask them for information relating to what they're going to be saying. After all, the duty to provide information is a reciprocal duty. We got to provide upon request something within the scope of bargaining. They got to provide within request something within the scope of bargaining. The legislature has said this was in the scope of bargaining. Go for it.
Okay, back to the union-friendly legislation that exists here in California, SB 285. It prohibits public employers from deterring or discouraging public employees from becoming or remaining members of any employee organization.
So much for free speech by employers.
Then there's SB 866, signed also on 6/27/18 coincidentally, and it does a number of things, and want to spend a little bit of time talking about it. There's a lot in that particular bill, so you'll certainly want to avail yourself of the opportunity in order to read the entire piece of legislation. But a number of things that it does. One thing it does, it talks about mandatory meeting and conferring before disseminating mass communications to public employees or applicants concerning public employees' rights to join or support an employee organization or to refrain from joining or supporting an employee organization. There's a requirement that you meet and confer over that. If the parties are able to reach agreement, which hopefully the parties are able to reach agreement, well then one communication document will go out. But if the parties can't reach an agreement and the employer decides to go ahead with its proposed mass communication, the employer must also distribute a communication of reasonable length provided by the union. In addition, SB 866 talks about the date, the time, and the place of a new employee orientation, establishes that the date, time, and the place of a new employee orientation shall not be disclosed to anyone other than to the employees, the exclusive representative, or a vendor that is contracted to provide a service for the purposes of the employee orientation. Going on, SB 866 provides some other very important elements. It establishes that the employer must allow payroll deductions for union dues. All requests for to begin dues deductions or to cancel dues deductions must be made to the union and not to the employer. The union is responsible for letting the employer know the amount of the dues deductions for employees. The employer must accept the information that's provided by the union on dues deductions for employees. If the union states that it's got written authorization to begin dues deductions, it is not required to provide the employer a copy of the individual authorization unless there's a dispute that arises about the existence of the terms of the authorization. And in addition, the union must indemnify the employer for any claims made by employees as a result of the payroll deduction. Continuing on, there's more in SB 866. We've talked about the duty to circulate and to meet and confer over the dissemination of mass communications. And then we've also mentioned that there's language that's similar to that language that's included in 2970, providing the date, the time, and the place for new employee orientation, and establishing that that information shall not be disclosed to anyone other than the employees, the exclusive rep, or a vendor that's contracted to provide the service during that orientation. Moving on, there's some more union-friendly legislation that you need to be familiar with. Government Code Section 16645.2 establishes that a public employer receiving state funds shall not use any of those funds to assist, promote, or deter union organizing. Any public official who knowingly authorized the use of state funds in violation of that provision shall be liable to the state for the amount of those funds. Jeff, did you have some comments?
Yeah, so as you note up here, that there's an old case, the Rio Hondo case, which was actually decided back when I was at PERB, that followed, in essence, NLRB precedent. It said that employers can freely express or disseminate their views, arguments, opinions on employment matters, unless the communication contains a threat of reprisal or a promise of benefit. You know, this is really severe. We're actually handling a case now. My partner and good friend Tim Young is handling a case that was brought against the Regents of the University of California by the Teamsters. It involves this very question about how far can a union go in this. That is now in Alameda Superior Court, and we'll see how that goes. Now we're about to talk about immediate requirements for public employers, but some questions have come in, and I want to address some, but not all of them. John, as to agency shop defined, asked about maintenance of membership in light of Janus. Good question. It was, can a member unilaterally change their status to non-paying Janus covered employees? And well, my own answer, Roland hypothesis, is no. If there's a maintenance of membership clause in a collective bargaining agreement or memorandum of understanding, the Janus does not cover this issue, but I think that a court is very likely to say, hey, you signed up, and you signed up under a contract provision saying that you can't pull out except during a particular time. And I doubt that the Supreme Court is going to go anywhere different in connection with that. Now, in the absence of maintenance of membership, of course, the situation is different. The member is required to abide by what's in the union constitution and bylaws. If there's some notice period or some escape timeline that needs to be followed pursuant to the constitution or bylaws, that could be something else. But in the absence of the agency shop maintenance of membership provision of the contract, current members probably can. John asked, is Janus retroactive? And we're going to be talking about that a little bit more, but I think the basic question is, it is not retroactive from the standpoint of your obligation or public sector union's obligation. But the question really is, well, when do you have to be stopping collections by? And we'll be talking about that in a minute. Now, let's see now. Heather, hello, Heather. Haven't seen you for a while. Heather asked an interesting question about AB 119. Let's see if you want to cover this one, Mark. And the question is, what if you don't have the personal cell phone numbers or email information? What do you do about that? Because the statute says you shall provide it.
Well, I think the response is, if you don't have it, you don't have it to provide. Would suggest that that's the appropriate approach. I'm not sure that you're required to go get that information if you don't normally collect it as part of your normal collection of information. What would you say about that, Mr. Sloan?
I think that's, from a logical standpoint, absolutely correct. And the union may be asking you for it anyway. And you got an obligation to engage in an interactive process with the union. See what they say about that. We're going to turn now to the immediate requirements for public employers and public sector unions.
So many of you, I mean, all of you are probably in the midst of complying with the Janus decision, and most of you had started those preparation really in advance of the actual decision. But we'd like to just review a couple of immediate requirements that at least we see that employers should be involved in now if they haven't already been involved in it. The first thing that you need to do is you need to review all of your MOUs to see if there are mandatory agency shop arrangements that are included in those MOUs. And if there are, then you'll continue to move forward. I guess the answer is if you're not covered by agency shop, if you don't have any of those provisions, is the answer, Mr. Sloan, stop, do not proceed to go, and do not collect $200. You've satisfied your obligation to comply with Janus if you don't have any agency shop provisions in the collective bargaining.
Yeah, the $200 you collect would only stem from a maintenance and membership provision.
Once you determine that you do have an agency shop obligation, then you'll want to go through and look at your payroll records in order to establish probably 3 categories of payers. First of all, there are members, those individuals who are dues paying members of the union. You would want to identify those because you don't have any responsibility under Janus in terms of dealing with those who are paying dues. The second category that you'd want to determine are those fee payers, those individuals that are affected by the agency, affected by Janus, that are paying agency fees. And the third category of fee payers would be religious objectors that, rather than paying the agency shop fees to the employee organization, are paying the equivalent of those fees to some charitable group. It's the latter 2 groups that are affected by Janus. And for those 2 groups, you would stop deducting the fee for those fee payers and those religious objectors immediately. And Jeff, are we going to deal at this particular point to come back and talk about some of the questions that were raised before that you said that we would deal with later in the presentation, or is it still going to be later in the presentation?
Well, we'll go to the next slide in a minute and we'll see.
Okay, sounds great. From practical experience, sometimes it's difficult in order to keep track of which category of employees that you have. There are some employers that I've worked with before that haven't distinguished really between the 2. So if you can't separate the fee payers, if you can't separate the union members from the other fee payers, I think the response is you'd ask the union in order to do so. 866 establishes the union or the employee representative as the provider or the source of that information. The next thing that we would suggest that you would do is to prepare letters to the unions and to the affected employees. We've offered a couple of letters, suggested letters in the toolkits that we've put together. The objective of the letter to the union is just to advise the union in terms of what the employer is going to be doing in order to comply, so that they're not surprised by actions that the employer is following. And the letter to the affected employees is to notify employee fee payers that fees that are being deducted from their paychecks are going to stop being deducted from their paychecks. And I think the important caveat is don't say or do anything that would deter or discourage an employee or a job applicant from becoming an employee organization member or authorizing dues to be deducted for an employee organization. Moving forward, we've got some hot issues that Jeff would like to talk about.
Yeah, so we have a question for you. And I'm not sure that from an interactive standpoint, we're going to be able to get your answers before we tell you our perspective, but let's give it a shot. As of what date must the deductions be discontinued? That's a very significant question, because if you wait too long, you're potentially jeopardizing the rights of non-members and could be in trouble, although the union is ultimately in trouble maybe because of hold harmless provisions in all of your MOUs or collective bargaining agreements, right? But as of what date must deductions be continued? Is it the date of the Janus decision, do you think? Is it, well, we can wait until the beginning of the next pay period? Is it wait for the Circuit Court of Appeal to rule upon remand? Is it work it out with the union? Or is it something else? Is there some other option in here? When must the deductions be discontinued? And before seeing if you have answers quickly, let me say that there's a difference between making the deduction and sending it on to the union. So if you've made the deduction, but haven't yet sent it on, and I don't know quite how your payroll system works in terms of processing payments over to the union, but if you're in that limbo period, that gives you an opportunity. And it gives you an opportunity to do D, which is work it out with the union. So our conservative advice would actually be A, the date of the decision, and D, work it out with the union. That's our conservative advice. But I think some employers are indeed deciding to wait until the beginning of the next pay period for practical purposes. Waiting for the Circuit Court of Appeal to rule, there would be a rationale for that, but I think that that is certainly not conservative advice in connection with that. Okay, a couple other questions, and Mark, while we're doing that, please do a time check on how we're doing. Brett.
We're doing fine in terms of time, Mr. Sloan.
All right. Brett has asked, well, can we give you more information on the new employee orientation and non-disclosure of location? Well, as to non-disclosure of location, that's law under SB 866. The interesting thing was 866, when it was signed by the governor? It was signed the day that Janus issued. So, that's in the law now. We have a question also from Brett about, let's see now, we got an orientation that the union participates in. We're currently negotiating the duration of the time they have. And my answer to that is, well, that's the right thing to do. And my experience, where unions come in and how flexible they are, how realistic they are, really depends on the union. And you can imagine which unions are going to be more flexible than others. So, what I've seen is unions typically come in with demanding an hour. My clients, I think, in general, end up saying, we're willing to give you half an hour. There are other aspects of this, though, that are important enough to be referencing, including, well, if it's a union rep who works for the employer, do you give them release time? And questions like that. And I think the good thing to do is to see what they say and caucus and deliberate before making a decision about what to do. Nate asked a question, current contract has provisions requiring employees to join the union within 30 days. If not, the contract says the union can request that the employee be fired. How does Janus deal with that? Let's see now. Well, Janus says that you can't be required to pay H&C fee, and joining the union would get rid of that. But something that says you have to join within 30 days, in my view, you got to get a lawyer's opinion about that. I can't give you a binding opinion, but even under the NLRA, which says union shop is legal as an exception to the general rule that unions can't discriminate against employees because of their participation or non-participation in union activity. Case law, and the key case is the General Motors U.S. Supreme Court case, says that even if a contract says that an employee must join, that provision under the law boils down and limits the employee's duty to tendering the equivalent of dues, initiation fees, and assessments. So even under federal law in the private sector, you can't join a union. So I would say that that language effectively should be dealt with the same as agency shop. But again, get advice on that. Let's see now, Jennifer, will we be providing template letters for SB 866? We'll take that under advisement.
Yeah, that's something that we'll take a look at. We have a toolkit, and I'd like to think of those toolkits as kind of living toolkits, so we can take a look and potentially include other communication templates in that toolkit. So stay tuned.
Yeah, and on the issue of this hot issue, Tori suggests, Tori, great hearing from you. Tori was an associate with the firm before she went on to be in the labor shop in Palo Alto. Her answer was compliance as soon as administratively feasible. And that's different than A, B, C, D, or E. But that's certainly a legitimate answer. And, you know, often the union's going to agree to that. And you need to assess whether employees who are non-members are going to take you on about that. My guess is that they would not. So just a guess. All right, so now we're going to move on. Gil, if you can help us out with this, to the next slide.
So back to immediate requirements, communications with affected labor unions. It's really a joint obligation in order to comply. As I had mentioned before, there is a letter notifying the union letter template in our toolkit, and we suggest that you take a look at that. And in essence, what you'd like to tell the union in that letter is what you're going to do before you do it, so that they're not surprised. You know, there may be provisions that are subject to effects bargaining, and the union then would have the responsibility in order to raise those issues, so that you can engage in effects bargaining at the request of the unions. Continuing on, communications with the agency fee payers. Again, there's a suggested letter template in our toolkit, but that letter to the fee payers is to inform them about Janus and the need in order to stop deducting agency fees. And we had further mentioned, if you have a question in terms of which category employees are going to fall in, you would rely on information to the employer that you would receive from the labor organizations on the designation of employees.
You know, there have been some questions, although one hasn't popped up through chat, about whether the union needs to be consulted or negotiated with respect to this letter. And that question comes from the legislative prohibition against mass communications of certain sorts. I know that some firms are taking the position that it should be run by the union in light of that legislation. That's conservative advice. I personally doubt that that's where even our union-friendly PERB would end up, recognizing partly that PERB just lost one of its two management-oriented representatives, Mr. Gregersen. But this is something that is worth talking to a union about to make sure you don't get unnecessarily in trouble.
So just a couple of the things about the union obligations, as we see it, that they have the same obligations that the employer has, and that is to stop the collection of agency fees and the fees from religious objectors. In addition, the unions need to be able to respond to questions from the employer about the categories of employees. Kind of an important thing in order to look out, in addition to those obligations, look for the unions to put into play a strategy in order to offset the loss of revenue due to the elimination of agency shop fees. This may include demands for reopener negotiations, which we're going to talk a little bit about later in this webinar when we talk about the various clauses that are in your collective bargaining agreements, as well as the obligations that those clauses create for employers.
Yeah, now before we go to the next section, which is regarding the next wave, there are a couple other questions. John asked how much notice must be given of the orientation, and what do you do if the union doesn't cooperate? My basic answer is that how much notice must be given is something that you would be working out with the union. There's a minimum specified in the statute. We'll pull that up in a minute, hopefully. What do you do if the union does not cooperate? I'm not quite sure, John, what you mean by that question, because if a union is not cooperative with respect to scheduling or working with you to work out the parameters for the union involvement in orientation, in the final analysis, you can move it forward, but is this subject to interest arbitration?
That's a very good question.
Let's take a look at that statute. Where you've dumbfounded the presenters here, and let's take a look. Justin, maybe you can help me with that. Jennifer asks, unions without agency fee, what do you do about that? I need to see that screen. Should you be sending notices inviting them to negotiate on terms for new employee orientation and details and all that? My answer is I don't think you have an affirmative duty to do that. If unions are asleep at the switch, they're asleep at the switch. Now, next wave, be prepared. This is what we want to talk to you about. And this gets into, essentially, how do we, now that once you have done your Janus compliance, what's next and what ought you be doing to be prepared for the next wave? The answer is, besides bearing in mind that a lot of this involves interaction with the union, you need to be doing some research and review of your contracts to know what your duty is and to know what your duty is not, because they're going to be coming at you in a lot of jurisdictions asking for things that you potentially do not have to give them or to do with them under your contracts. So one issue, savings clause. And we'll be giving you a couple examples of that. I think, Mark, we do have time for that.
Yes, we do.
So almost all MOUs and collective bargaining agreements have what we call savings clauses, or they're sometimes called severability clauses. I can't remember the last one that I've seen that did not have one. And a savings clause or a severability clause provides that if a contract provision becomes illegal or unenforceable, the remaining provisions are unaffected. Now, sometimes unions say it's premature to say this particular provision goes out. Sometimes the language in the savings clause actually may support their view, but on this one, what I've seen is that all unions recognize that agency shop is history. But some savings clauses, in addition to saying the provision goes out but the contract remains in effect, some of them say you have to reopen the offensive provision. Now, if there's no savings clause, then as we say here, the contract would be subject to normal contract law principles. And the union could argue that the contract has to be reopened if there is no savings clause. But this then gets into another issues that we'll talk about, which is the zipper clause. So here are a couple of interesting samples, savings clauses. And interestingly, Mark and I did a little bit of search, and we found a couple of different approaches that people have taken in their contracts. This one came from contracts from different jurisdictions whose workers were represented by the same union. So example A said, in the event that an article, section, or portion of this agreement should be held invalid and not enforceable in court of competent jurisdiction, the decision shall apply only to the specific article, section, or portion. And upon issuance of such a decision, the city and union agree immediately to meet and confer upon a substitute for invalidated article, section, or portion thereof. Well, this is an example of how we really need to look at these savings clauses, right? Because that one is pretty clear. You got to sit down and negotiate a replacement. What's a union going to be asking for as a replacement? Certainly maintenance and membership. And who knows what else, but I think typically it would be maintenance and membership, but they will throw other things in there potentially. And what I'd have to say as to that, going off script a little bit, is that remember that even PERB case law from the union-friendly PERB talks about how when you're negotiating impact, your duty is to negotiate over the direct impact of a change, not over indirect impacts, hypothetical impacts, or the like. That's not legal advice because there are other aspects to this, but it's just an interesting point to make. Sample B, this is more normal. If any provision of this agreement or the application of such provision should be rendered or declared invalid by any decree of a court of competent jurisdiction or by reason of an existing or subsequently enacted legislation, the remaining parts or portions of this agreement shall remain in full force or effect. What does that mean? Well, that means that the contract provision relating to agency shop evaporates. That's what it means. But what your duty is after that depends upon the existence and the content of your zipper clause. And they're not always called zipper clauses, but that's our kind of labor law shorthand for it. A zipper clause addresses the right or duty of a party in bargaining during the life of a contract. And the typical one says that neither has an obligation to bargain over matters covered by the agreement or over matters within the scope of bargaining. That's a typical zipper clause. Here's an example. Let's see, A, this agreement supersedes all other agreements. It's nice language. B, neither party shall be obligated to meet and confer during the term of this agreement on any matter within scope. However, if during its term the parties hereto mutually agree to modify, then the change shall be effective if and only when it's reduced to writing and executed by the authorized representative of the city, okay? Okay, so that's a classic zipper clause. So agency shop goes away by virtue of Janus. Union comes to you and says, we want to negotiate with you over a replacement. You look at your zipper clause and it says this. Well, let's see now. Is agency shop within the scope of bargaining? Oh, it used to be. It's not now within the scope of bargaining because it's illegal. Okay, well, do you have a duty to bargain over a lawful replacement? Possible answer, talk to your lawyers, but possible answer is, which I kind of like, well, a lawful replacement like maintenance and membership would be within the scope of bargaining. And if that's true, then you might well have an argument that you don't have to reopen in light of the content of your savings clause because the agency shop thing went away. That then gives rise to a significant relationship question, because if you don't give them something to replace it, even if you're not obligated to reopen, what's going to happen?
So it's like it could be viewed as a temporary waiver of duty to bargain, but then when that contract expires, then you're still faced with the issue.
Exactly. But what you need to bear in mind is long-term strategy. You know, what's your relationship with the union? What does maintenance and membership cost you if that's what you're asking for? You know, some hardline jurisdictions might well say to the union, we don't even want to sit down with you because here's our zipper clause. What's that going to do to a relationship, and what might they do about that? Are they going to file a grievance if you have binding arbitration? Well, that's going to happen. Are going to file a charge on you with PERB relating to alleged refusal to bargain over something that's within the scope of bargaining. those are those are some things to take into account when you decide what to do about the union demand. That's a policy call, which needs to be informed by your view about what the contract does require and by the advice that you get. But a couple other, just general comments about the intriguing aspects of Janus and how that they tie into what you should be doing in anticipating next steps. Another thing is you never know what's in the rest of the contract that might impact this. So besides looking at the zipper clause and at the savings clause, do a full review of your contracts just in case, because that's going to help you avoid unpleasant and unanticipated surprises. Now, what about employees seeking refunds or damages? Damages for what? Well, they may say, hey, the Supreme Court said that a boot is out, and it's always been out. It's always been wrong. Agency shop has always been illegal. Hypothetical employer might say, I want all my money back. What's the answer to that? I think the answer to that is, well, on the one hand, Janus said that. On the other hand, as Tori pointed out, if you're cutting it off at least at the point where it's administratively feasible to cut it off, you should be okay. What if they seek a refund? This ties into what I said earlier, and that is conservative way of approaching this would be once you receive Janus, that's where it would be cut off. If you didn't have time to cut it off at that point, and most jurisdictions didn't because you can't act immediately, then you could consider saying to the union, we got the money from the employee, but we should be prorating, and therefore, even though we collected it, what do you think about us not passing that on to you? Some unions would say fine, and some would say don't do it. And your final determination on that, if you take that position, figure out what your legal exposure is and take it from there. Further on now on anticipated union actions. And let's see, Mark, what if the union makes some demands to bargain, and what might those demands be?
So who knows what those demands are going to be, but some of the things that we would suggest that you are going to anticipate would be some replacement to agency shop. Maintenance of membership is one of those replacements. Another thing that you might see is a suggestion that agency shop continue unless the employees opt out. Additional orientation sessions where the union would ask for an audience with those agency shop payers in order to conduct an orientation session with those groups. Additional access to employee meetings with fee payers, employer payment of costs of arbitration and fees as the union attempts to pass on some of those costs, and then cancellation of no strike clauses.
Of course, another piece of this is what are they going to do to solidify their membership and recruit new members? You're going to see, and I'm sure a lot of you are already seeing, increased militancy on the part of unions.
Shifting the financial burden to non-members as they look for ways for paying for the representation, for example, in disciplinary cases, and then shift the burden to non-members in order to pay some arbitration fee.
And that's going to raise some interesting legal issues relative to the duty of fair representation and what a union can do about this. Fortunately, that problem is going to be in the union's court rather than our court. And of course, they're going to be the least aggressive unions like SCIU, I think, are going to be protesting any speech or action that they view as deterring union organizing. And we just finished writing another article on Janus, and we had to observe what's probably the obvious, and that is given the just fundamental bedrock principle of free speech, it should be of concern not just to employers but also to the public at large that there is legislation signed by our governor that basically is a gag order against public employers spreading information that is non-coercive and that is accurate. Mark, what about the issue of increased unfair practice filings with PERB?
That's always a possibility. When I was with PERB, the Janus effect was debated, and I think it was just generally accepted that the filings would increase with PERB. That would additionally tax an already taxed agency in terms of resources. PERB, as many of you know, has extreme periods of time in order to process charges that come from lack of resources, and the anticipation is the effect of Janus is going to continue to tax those resources.
Now, Mark, didn't PERB just get a significant increase in state funding?
Yeah, there was, and I can't remember exactly what the dollar funding was. It was approximately $1.5 million, but it was, I believe it was 7 additional positions were included in this year's budget, which was welcome by PERB, certainly when I was there. But I think the important thing to add is that it wasn't the level of resources that, in my opinion, that agency needed in order to effectively serve its constituents.
And that is Mark speaking, I think, in the voice that he spoke as the chair of PERB. And he's also speaking that now as a senior consultant to our group, who now, instead of being a neutral, is out there doing negotiations and consulting on HR and labor relations matters with our clients. Little pitch there. Okay. Now, before we get to bottom lines, and time is just about run, although we started a little bit late, we want to make sure that lawyers get their full hour in. John, getting back to your question about how much notice must be given on the orientation, exclusive representative under Government Code 3556 shall receive not less than 10 days notice in advance of the orientation. And then beyond that, a bunch of stuff is subject to negotiations, and do take a look at Government Code 3557A and 3557C. And Michelle, good hearing from you. I hear you have a very good law firm advising you guys. Here, the MOU does not require reopeners or renegotiation if a position is found unenforceable, but SCIU has asked to meet and confer about a replacement fee. What is the employer's obligation? And my answer is, well, I want to look at the contract to be sure, but my guess is, based on my recall of your contract, you probably don't have one, but that then gives rise to the relationship issues and to the question of what is SCI going to do if you say no. And the answer may be they may be doing a lot against you. And then the question is, as Mark said, well, when your contract expires, they're going to ask for it anyway. Take that into account, especially if the contracts are coming up soon. So we're not saying what to do. We're just giving some thought about how to approach that question. Let's see now. So with that, time's about running. I'm sorry we didn't get to all questions, but what we want to do now is talk to you about bottom line. And the bottom lines are, Janus compliance is a mutual obligation. Second very important point is that talking with the union in all aspects of implementing Janus is a good idea, and there is no downside, except that they may be unreasonable. And if they're going to be unreasonable, you got to do what you think is right, and bear in mind, look at the language in the contract to see what the hold harmless and indemnification language is. Because I can virtually guarantee you that every contract out there in the public sector says if there's a problem with compliance related to agency fee, the union will be on the hook if you get sued. Third point, be mindful of new legislation requiring employers to refrain from deterring or discouraging union membership, as Mark has talked about, and then beware the challenges to come as unions struggle to increase their membership in light of Janus. Any parting words, Mr. Gregersen?
I just wanted to emphasize, Jeff, some of the things that you've said is that compliance with Janus is a mutual obligation, and the single most important factor, I think, in both parties satisfying that obligation is to talk. Obviously, Janus is a significant impact on, has a significant impact on public sector labor unions, and talk is really good. And in that talk and discussion, I'm confident that the parties are going to find solutions.
Okay, we have time for 3 more questions. 1 or 2 or 3. 1, will we be providing a link to the presentation? Ernestine, will we be sending out this presentation?
Yes.
Is that a policy question for the partners to consider? I think it is, and the answer is yes. We will be sending out either a link.
You should request.
Actually, it would be better if you requested it. Just send it info@sloansakai.com. Nancy and Brett, thank you for your question on that. Michelle asks, can we negotiate MOU provisions that differ from 866 requirements, and are the provisions enforceable? Well, my answer to that would be, if 866 doesn't require it, but you negotiate it anyway and you reach an agreement with the union, then that will be enforceable. And I would also say that if it differs from 866, it might well be viewed as a permissive subject of bargaining, but not an illegal subject of bargaining. We've dealt with this over the years.
We have.
And as a permissive subject of bargaining, it's fine to go over that. John asked, if we are going overtime, can we address or explain maintenance of membership more, and whether there is any special language to create it? Okay, we did not see a groundswell of questions from folks. Yeah, to go over. So John, we're gonna close at this point, and anybody who wishes to hold over to hear the answer to John's question, you're welcome to do that, but we have hit our hour. So we thank you for your participation, and must note that other updates as they become available. For those of you who aren't aware of our managing partner and friends, Tim Young's blog, you'll see updates as they become available, just as he updates everything related to California labor laws that comes in. His blog is at www.caperb.com. So thank you so much. And we're going to keep the line open, but consider the webinar closed. Take care. Bye-bye. Okay. Let's see, where's John's question?
Oh, well, his question was just more detail on the maintenance of membership, as I recall.
Okay, maintenance of membership, we can send you a sample clause from a contract, but maintenance of membership basically says that employees don't have to join a union, and they don't have to pay an agency fee. But if they do join the union, then they will be obligated to maintain their union membership, typically for the life of the agreement. As Mark noted at the beginning, not all statutes call for maintenance of membership. MMB, as I recall, doesn't call for maintenance of membership, but there are other statutes that do. But maintenance of membership is something that's within the scope of bargaining. The typical maintenance of membership clause is one that says that the employee has an escape period toward the end of the contract so that they can pull out from membership. And the reason that clause is in there is because if there's a contract requirement that you maintain membership, and if the parties enter into a new contract without a gap, without that escape clause, they could be perpetual members against their will, which would then give rise to a potential claim of constitutional dimensions. So it would be important to put in an escape clause. And John, if you want us to send you a sample or two, send an email to info@sloansakai.com. Anybody else want to see a sample as well? Okay.
If I could add just
please.
A couple of things to that. All it does is really just to provide the union with a defined income level for the period duration of the contract. Otherwise, there would be an incentive, a potential incentive for people to drop their membership and reduce the income that the labor union would get even more than the loss of agency fees.
Yeah, John asked an intriguing question. If we have agency fee, that means we don't have maintenance of membership. Well, if your contract doesn't have maintenance of membership, then you don't have it. But let's play that out. Let's say the contract says, as many do, either you have to join or pay a fee. People elected to join. Now, Janus really addresses not the people who elected to join, but the people who elected not to join. But John, I think that you raise a really interesting question, which is that if and frankly, I need to think through what the answer is.
Right.
The interesting question is, if the contract says you must join or either pay a fee, and somebody said, oh, well, geez, I only joined because I might as well have the benefit of joining, which is I get to vote on the contract and maybe be covered by an insurance program. So that's why I joined. Then how does Janus impact that? And my answer is, well, let me see, the court really didn't address that. That would be a whole new lawsuit. I want to ponder that a little bit more, but you raised a good question that
We haven't discussed it.
in some ways that's an obvious question, but sometimes there are obvious questions that are very, very insightful and cause lawyers to say, gee, let me really think about that. Wendy in Colorado. Well, you're in Colorado. What do you care? Isn't Colorado a right to work state? I don't know. Okay. Wendy, nice hearing from you. Would advising an applicant that the employer is going to give out email and cell numbers be considered deterring activity regarding joining the union? Wow. So you're talking about a mass mailing to employees through email or whatever, that the employer is going to give out email and cell phone numbers. That's an advisement. I don't know, I'd say it's probably okay, but why are you doing that and how are you going to word it? Because if you're sending out an email and saying, well, want to let you know that we have to do this, and you word it in a way that suggests that you want people to object, that could raise an issue. I don't think you have any obligation to let people know. Again, to be safe, talk to the union. They're going to probably say, we don't want you to do it, and you got to logic that through. Okay, again, we're over time and the webinar is over. And lawyers on the line, we're not going to keep going for another half hour, so you're going to get a 1.0 instead of a 1.5 unless we keep getting a lot of other questions, and 1.25 doesn't count. So unless you get 1.75 from somewhere else, or 1.25 times 4. Gina asks, if members want to stop paying dues, do they need to wait until the contract's up? If members want to stop paying dues.
Answer is it depends upon what your contract says. If there's provision that allows an early out, then I would think that might potentially be an issue.
Yeah, I mean, I think that there's probably no need to wait until the end of the contract if there's not a maintenance and membership clause.
Correct.
But then this does tie into John's question, and it's something to be pondering. Though you do have to rely on the union to tell you who has ended their membership. Those are all the questions we have. Great talking to you in this very modern digital way. Have a great day, and I think we're all looking forward to the weekend after a very hard July 4th holiday. Bye-bye.